start with a scenario that might sound familiar. Imagine you're an accused in a cheque bounce case. You're caught up in legal proceedings far away from your home, causing you not just financial strain but also unnecessary stress. So, a thought crosses your mind. Can I request to transfer my case to a court closer to home? This situation is more common than you might think, especially given the rise in cheque bounce cases under Section 138 of the Negotiable Instruments Act or NI Act. The answer to this question, however, isn't as simple as one might hope. It involves a delicate balance between the rights of the accused and the efficiency of legal proceedings. Today, we are going to dive deep into whether an accused person can file a transfer petition in a cheque bounce case. We'll explore what the courts have said on this issue, recent judgments, and what you can do if you find yourself in a similar situation. Stay with me to the end as I will also give you some tips on how to navigate this tricky situation. Here's a summary of what we're going to be discussing. First, Section 138 of the NI Act, understanding the basics. 2. The accused's right to file a transfer petition. Can they request a transfer? 3. Judicial precedents, key judgments and their impact. 4. What to do if your rights are violated. Practical advice for the accused. 5. Recent updates, important changes in the law. Now, let's dive deeper into these points to understand them better. Before we tackle the transfer petition issue, let's quickly understand what Section 138 of the NI Act covers. Simply put, it deals with the dishonor of a cheque due to insufficient funds or if the amount exceeds the arrangement made with the bank. If a cheque bounces, the drawer, the person who has issued the cheque, faces legal action which can result in imprisonment or a fine or both. Here's the thing, cheque bounce cases aren't just about money, they are about intent and timing. The law provides a 15-day window for the drawer to settle the amount after receiving a notice from the payee. If the drawer fails to pay, the payee can file a complaint. Now, the question arises, can the accused, who may be facing trial far from home, request the court to transfer for the case to a location more convenient for them? Let's explore that next. The short answer is no. The accused cannot seek a transfer of a cheque bounce case at their own instance. The Supreme Court has made it clear that in several judgments. In a notable ruling in 2023, the court emphasized that a cheque bounce case under Section 138 cannot be transferred based solely on the accused's convenience. In the landmark case of Himanshu Yadav vs. Dinesh Gupta, the Supreme Court ruled that the transfer of a cheque bounce case cannot be sought at the instance of the accused. Justice Abhay S. Oka remarked that while the accused may face challenges in attending the trial from home, the intent of the NI Act is to ensure swift justice for the complainant. Allowing the accused to transfer cases based on their convenience would undermine this objective. The court further clarified that the principle of justice delayed is justice denied applies not just to the accused but also to the complainant who is seeking recovery of their dues. This ruling reiterates that cheque bounce cases are designed to provide a speedy remedy to the aggrieved party and the accused cannot derail this by seeking transfer at will. But this does not mean that the accused has no other options. Not quite. Let's see what can be done if your rights are violated. While the Supreme Court's ruling makes it clear that transfer petitions from the accused are generally not entertained, that doesn't mean you're entirely helpless. Here's what you can do if you feel your rights as an accused are being compromised. First, approach the higher courts. If you believe that attending the trial in a distant location is causing you severe hardship, you can approach the higher courts, the High Court or Supreme Court under specific grounds such as health issues, safety concerns or personal incapacity. The courts may consider your plea if they find valid reasons. 2. Request for adjournments. If attending the trial on a specific date is a challenge, you can request the court for an adjournment. provided you have valid grounds. 3. Legal representations. You can also appoint a lawyer to represent you in the trial, ensuring that your presence is required only when absolutely necessary. Remember, the legal system aims to balance the interests of both the parties, and if you present a strong case, the courts may consider your situation sympathetically. There have been some interesting developments in the legal landscape regarding cheque bounce cases. In a 2023 ruling, the Supreme Court reiterated that the power to transfer cases lies primarily with the complainant and the court, not the accused. This reinforces the complainant-centric nature of the NI Act. Furthermore, the introduction of digital payments has seen a decrease in cheque bounce cases, but they still remain a significant legal issue. To wrap things up, let's quickly recap. First, Section 138 of the NI Act deals with cheque bounce cases, providing a legal remedy to the payee. 2. Transfer petitions. The accused cannot file for a transfer of the case based on their convenience, as per the latest Supreme Court rulings. 3. Legal options. While transfers are not possible, the accused can seek relief through adjournments, legal representations, or higher courts. 4. Recent developments. The courts continue to emphasize the importance of swift justice in cheque bounce cases, with a focus on the complainant's rights. If you ever find yourself in such a situation, it's crucial to understand your legal rights and consult with a lawyer to navigate the process effectively. Thank you for watching. If you found this information helpful, please like, share and subscribe to us. Stay updated on important legal topics. If you have any questions, feel free to drop them in the comments below. Take care and bye.